Charlotte, you're in charge of the next section of our presentation, and you're going to talk us through the individual development plan.
Yes, I am. Okay, so part 5 of our talk is in relation to individual development plans, which will be the Welsh equivalent of the education, health and care plan that we see across the border. So moving to slide 15.5.1, what is the individual development plan? Well, if the child's maintained school or the young person's further education college decides that a child or young person has additional learning needs, it must prepare and maintain an individual development plan for them, an IDP. And it must do this unless one of the exceptions in section 12.2 of the ALN Act apply. And those are, firstly, that the governing body considers that the child or young person has additional learning needs that may call for ALP it would not be reasonable for the governing body to secure. So the first exception to the rule that it's the school or college that must prepare and maintain an IDP is if the ALP that's in the IDP is such that you wouldn't expect a school to secure it as opposed to a local authority. So it's obviously difficult to know anecdotally, it's obviously difficult to know at this stage how that's going to be viewed, but typical examples would be things like full-time one-to-one TA support, which tends to be the sort of cost that you would expect a local authority to fund and not the governing body of a school. Therapeutic provision over and above what that school may have attached to it anyway. That sort of provision is the kind of thing that we're talking about. Secondly, if the governing body cannot adequately determine what the extent of the ALP required would be, or cannot adequately determine what the needs would be. And in that circumstance, the governing body can refer the case to the local authority that is responsible for the local authority to make the decision. So it's interesting because under the new regime, if you have ALN, you will get an IDP as a child or as a young person. And that's different from the current situation, of course, which is that we have some children with special educational needs who will be on School Action or School Action Plus and who will get their special educational provision directly from the governing body, and others who have statements and will get their special educational provision from the local authority. So I quite like that, and we'll talk about at the end of the session how Mike and Chris feel about that, but I quite like that. I think it's nice that we now have a situation where there aren't going to be particular tiers of mechanisms for provision. If you have additional learning needs, you will get an IDP. And the difference will be in who is responsible for preparing and maintaining it. And that will depend on the severity of the needs and the extent of the special educational provision. We're not saying that anymore. The additional learning provision that the child or young person will need. Other exceptions to the principle that the maintained school or FE college must prepare and maintain the IDP are if the governing body requests a local authority in England to secure an assessment under the Children and Families Act. So in some situations, you have a young person or a child who is being educated in Wales, but their responsibility for them lies with a local authority in England, or if a local authority in England already maintains an EHC plan for the child or young person. There is another important distinction, which I don't think is expressly in either the Education Act or in the equivalent English legislation, which is that if the plan is about a young person, the young person has to consent to the plan being prepared or maintained. And if they don't, then the plan cannot be prepared and maintained, however much everybody might think that young person needs provision. Interesting questions about capacity there, maybe, that we can come back to. So moving on to point 5.2. If the local authority decides that a child or young person has ALN, it must prepare and maintain an IDP for the child or young person. Or if the child or young person is or is going to be a registered pupil at a maintained school in Wales and the local authority considers it appropriate, they can either prepare an IDP but direct the governing body to maintain it. That might be interesting later on. Or direct the governing body of the school to prepare and maintain a plan. And And again, that is the case unless the decision relates to a young person who doesn't consent to an IDP being prepared or maintained, in which case the local authority can't do that either. Going on to point 5.3, what should be in an IDP? Well, again, we have, under the Education Act, we have parts. Under the Children and Families Act in England, we have sections. Under this Act, we have parts and we have sections. So, Part 1, Section 1A will contain basic biographical information about the child or young person and contact details. Section 1B will set out who is responsible for the IDP, so it will identify who is maintaining it. Is that a school? Is that the local authority? And when will it next be reviewed? And Section 1C will contain the personal profile, so in other words, the All About Me section that we see. Part 2, Section 2A will effectively be old Part 2, so a description of the child or young person's additional learning needs. And again, we'll come back to that interesting thing, description as opposed to specification. Section 2P, description and delivery of the child or young person's additional learning provision. Section 2C, description and delivery of ALP to be secured by an NHS body. I think that's going to be interesting given the way that the Welsh healthcare system works, but I'm also going to defer later to Chris to talk about that. And Section 2D, placement at the named school, other institution, or board and lodging, which again is a nice additional clarification that has sometimes caused problems across the border in terms of what if you've got something that is arguably not a school and may not qualify as another institution. Particularly useful, I think, for young people who may be getting provision that consists of, that is delivered partly in a residential setting such as supported living accommodation and partly in an FE college. In Part 3, you'll have a record of it. 3A will be the record of information used to develop the IDP. So that's where you will summarise the reports that have informed the content of the IDP. Section 3B will contain a timeline of key events. Section 3C will deal with any transition issues. And Section 3D will deal with travel arrangements. Going to 5.4, what about enforceability and review? So the Act says that a maintained school, FE college or local authority that maintains an IDP must secure the ALP that is described in the IDP. So that again is a mandatory obligation, and I am suspecting that we're going to see an authority fairly soon afterwards to the effect that that is non-delegable in the same way as duties are non-delegable now. So in other words, if a school or a local authority or an FE college is the person that is maintaining the plan and delivering the provision within it, they're not going to be able to defend any arguments about non-provision by saying, oh, well, we delegated it to somebody else to do and that body didn't do it. In terms of annual review, again, it's annual review within 12 months of the date that the initial IDP was sent to the child, young person or their parents. So it can be within any time during that first 12 months, but it mustn't be further than 12 months away from the date of the creation, or 12 months from the outcome of the previous review, the date when that was sent to the child, young person or their parents. And it's important just to bear in mind that as with the Children and Families Act now, a successful tribunal outcome does not reset the review programme. So you could, in principle, have a situation where you get your successful tribunal outcome, and 3 weeks later, there has to be an annual review because of this timetable. Although obviously you would expect in that situation that the local authority or the school would not be messing about with the provision that the tribunal had ordered. Okay, so that takes us to the end of part 5.
Sorry, Charlotte. Sorry. Thank you. I was going to say some very interesting points that emerge there, aren't there?
Very much so.
I mean, I like the points that you made about the introduction of a child that, for the first time, who could refuse the plan. I mean, I've said it before. I'll say it again. When asked oneself, I do often, would I be here today talking as a solicitor if I did today what I wanted to do when I was 12? And, you know, one wonders that giving children a voice is critically important. Of course it's important, but sometimes children make the wrong decisions.
Yeah, It's an interesting question, isn't it? I think it's not terribly clear, but I think it's going to be the case that up until 16, parents will continue to be able to make the decision. I think the problem's going to come when you have young people. Well, it's interesting. I mean, in practice, are there going to be that many young people who are going to refuse to consent to an IDP? There will almost certainly be some, but whether there will be droves and droves of them is genuinely up in the air, because I think most young people who have additional learning needs are quite motivated to seek help for them, provided it's offered in a way that is acceptable to them.
Well, maybe I could throw in pathological demand avoidance syndrome.
True, yes. Yes, there are definitely going to be some young people who will find the idea of an IDP unacceptable, almost because it might help them. We know that, unfortunately, some young people will just really struggle to accept that help. And the difficulty, of course, Mike, is that some of those, you certainly cannot assume that a young person who's got PDA or ODD won't have capacity to make that decision, because, as we know, a bad capacitous decision is still a capacitous decision.
Yeah. I think that, so just to confirm, it is in the interpretation of the Act, the section of the Act, that a young person means a person over compulsory school age but under 25, which I think is interesting, because normally they do define it as 16, which obviously would generally be relevant in terms of compulsory school age. But it does mean that if compulsory school age were to move up to 18 or beyond, then that would automatically shift with it, which is an interesting point of drafting. But yes, the Act, I will say, and there are certain things, obviously, today we've talked about, this presentation is a general presentation, kind of an introductory presentation for people in relation to the ALN Act. And there are other factors, such as, how to support a child or young person who may not have capacity, or certainly a young person without capacity, in making this decision, and supporting them through appeal if need be as well. So the Act actually deals with that quite specifically. We haven't talked about it here because we thought it might be a bit too long and a bit overwhelming to deal with that as well. But certainly the Act does cover it, which I think is very helpful. And I agree with both of you that, it is a really tough balancing act. I think it's good that it's in the Act that a young person needs must be considered, but I agree with you, Mike, that there is a real concern that if a young person, perhaps because of their needs, or perhaps because they're just at a stage of life where perhaps they really don't want to feel different, and we do get that a lot as well, people don't want to feel different, maybe declining an IDP, and then, of course, nobody able to compel them, even though it might be a unified agreement between parents, professionals, teachers, etc., that it's right for them. Obviously, people with capacity have the right to make an unwise decision under the Mental Capacity Act. So, of course, this could very well fall within such a category. So it'd be interesting to see how that's in practice. Hopefully, it will prompt better education of young people, where there's coming around better support of young people to make informed choices. And I think that's really the intention of the Act, and I think that's to be lauded. But yes, absolutely, I think there's certainly a risk there. And I'm going to preempt your NHS question, Charlotte, as well, because I saw that smile come across when you mentioned it earlier. So again, that is something we haven't specifically addressed in this seminar, but there is a specific section, or specific sections, I should say, regarding the involvement of NHS bodies and local health boards in the decision regarding ALN. These are sections 20 and 21, for those of you at home taking notes. And they require, they essentially empower local authorities and those at mainstream schools to actually refer on to a local health board or NHS body the question as to whether they might be able to offer a person who might have ALN those services. It's a little bit of a wishy-washy duty, I must say, which is one of the reasons why I felt it didn't need to be included in the basic introduction of the Act. But it does allow them to do so, and where such a referral is made, then the health boards are required to essentially come to a decision. And if it does identify treatment, then it must secure that. And of course, that's Chris, why it would be in the plan.
Chris, one of the beauties of this, though, this is one of the good things, is that we can say, can't we? And those viewers who are watching this in England, for example, might often confront arguments whereby the councils try and compartmentalise difficulties into different sections: education, social care, health. Isn't this sort of a more wider, more general acknowledgement that one has to look at a child more holistically?
Yes, I think there are certainly good things to it. I suppose, as any lawyer for children and young people, they'd want more cast iron duties on public bodies. Of course we would. And I'm sure our colleagues who are public body lawyers would like far more vague duties as well. I suppose I'm looking at it very much from the lens of, I want greater clarity and greater responsibility on those public bodies. But yes, I think it is good that it's in there. It's improving the breadth of the coverage, certainly under the Education Act, making it more akin to that in England. But equally, as you say, Mike, perhaps giving that broader scope as a way to just get more provision for children and young people. So yes, I think it's good. I just think it could be better, but perhaps I'm being too demanding.
Charlotte, I'm going to look to you on this because I know that you are you're with me on this about my concern about the potential conflict between schools and parents. Interesting from what you said in your presentation, just a couple of points really. One is rather ironic that you have a situation in which a school might say, well, this young person's needs are too complex, so we ask the local authority to help. And the decision is then made to send it back to the local authority, to the school, to actually maintain, draw up and then maintain the plan. I mean, there's one point that is of concern to me, but that's not the end game, isn't it? We all know that the drawing up of a plan is not the end stage. A plan is a living instrument. And once a plan is then maintained by the school, from day one, a child, let's say, who's very complex, does that just eradicate the idea that that child is no longer so complex that you don't have to try and be really careful about how you tweak the plan in the future at every annual review? Are you going to require that expertise, time and time again? So how many plans are going to be left in a state that we often see? Well, we've seen right across, whatever part of the UK you might live, you have a statement or plan drawn up from when a child's 5, and it doesn't really change much when they're 12. So the monitoring of the plan in the future is going to require that level of expertise. And it seems to me that and whether you agree with me, but this entire shift from the concept of making sure the assessment is thorough, and the fact that we are going to come on to this, I know, in the next section of the presentation, over what you can appeal against, but to the idea of what should go into the actual plan itself, all we're doing is shifting the emphasis from everyone gets a plan if you qualify for additional learning provision, if you're likely to, if what you need is additional to or different from the provision that's typically available in mainstream schools or colleges in Wales, but the shift is going to be onto the drafting of the plan itself and what should actually be the detail of that plan, the flesh to the bones, if you like. And the idea that you can do that without recognizing the critical importance that should be played on getting proper expert opinion causes me concern. It has always caused me concern, because not least due to the fact that from practicing this subject as long as I have, even in England, where the code of practice is quite specific, as is the regulations about what advice you should obtain when you're before you draw up a plan, leaving it vague and discretionary about what expertise you should call for makes me very concerned. And I think that those clients that come to us as experts, we know what needs to be put into plans because we have the experience, we'll probably get good plans. But what about the many thousands of young people who don't have that expertise and rely solely on the advice and opinions of a school that might see it not necessary to get that level of expertise, not only at day one, but throughout the child's course at school? That is a matter of concern. And I also think, whether you agree with me on this, Charlotte, because I'm talking a lot here, but I also concerned about the point that Chris made earlier when he responded to my point, very respectfully disagreeing with me about the feud between the parents and the school. The idea really is, what I don't like about this legislation, it fills me with fear. I share Chris's optimism. I want to be optimistic. Of course, I live in hope that things will not be bad and things will go really well. But I am concerned that schools are being on the front line here, time and time again, not only in the decision, but in the maintenance of the plan. The questions about whether the school then is complying with it, the questions about enforcing change to the plan, and the idea about whether or not, at annual reviews, whether or not it's actually properly being treated as the living instrument that it is, I think is putting parents and schools too much at loggerheads together, or at least potentially. I hope not, but potentially. That's what my concern is. So to elaborate on the point I was making, Chris, earlier to you, these are the points. As we go drill through the legislation, you start seeing the exposure of schools to potential legal challenges, and that fills me with dread.
I can certainly see that. So I'm going to change tack, Charlotte. I know we didn't put it in the slides so far, but in terms of placement, so you read out there, obviously, that the placement, boarding or lodging is to be in there. But under section 14.6, and this is where local authorities preparing a plan, a similar provision exists for those. No, it is actually at the local authority level, where it essentially says that if the reasonable needs of a child or young person for additional learning provision cannot be met unless the local authority also secures provision of the kind in subsection 6, which is a place at a particular school or institution, board and lodging, the authority must include a description. So we see a shift of emphasis there, because it's saying if the child or young person's reasonable needs cannot be met unless you name a particular placement, or cannot be met unless you name board or lodging, then you must include it. But that seems to suggest that as long as the needs kind of may be met, or you're not certain that they cannot be met without naming a particular institution, you don't actually have to specify a placement at all. So that seems to be quite a shift from where we are currently with statements and EHCPs where you must have a placement. So what are your thoughts on that point? Do you think there's an area of concern there?
Well, I think that you do have to name a placement. It's interesting, isn't it? You do have to name a placement in a school, because we know that the code of practice the code of practice says that the IDP has to include information about the place at the named school. Yeah. I mean, it's going to be very interesting if we end up with a decision that says that under this statutory regime, you don't need to name a place in the IDP at all. I think that would be bizarre, to say the least.
Yeah, it's interesting.
What we're really looking at is a situation where there remains a dividing line between ALP that a school or institution can offer and ALP that only the local authority can offer. And so I think what's going to happen in practice is, where the governing body is maintaining the IDP, the IDP is just going to name that school, isn't it?
Yeah, of course.
Because by definition, if that school says, well, we just can't meet need,
then it has to go to the local authority.
Yeah, then it would have to go to the local authority. So I think probably a lot of these things will kind of pragmatically come out in the wash, but I can definitely see scope for some interesting challenges here.
Yeah, I found it really interesting the way it was drafted. The good news is that Section 9 of the Education Act 1996 is not amended by this. It will still exist. So parents can still express a preference for a school, and the duty under Section 9 to name or to consider to name that placement in accordance with wishes still applies. So that's good. So that's not changed. But there's no longer that specific naming or that duty to name like we see in Section 39 of the Children and Families Act. So, yeah, I'm hopeful for you as well. I think that's what we're talking about, is because it's coming into force later this year in September. We don't quite know yet how this is going to be implemented on the ground. And a lot of these issues and concerns we raise can be avoided with good pragmatic implementation. So let's hope that we get it. So Charlotte, let's say we do have a plan that we don't like at the school or local authority level. So can you tell us a bit about what parents might be able to do there?